Good afternoon, everyone. Thank you so much for joining us today. We've got a great webinar in store for you called Patenting Life Science and Medical Device Innovations. As you all are all aware, life science and medical device innovations form the intersection of science, engineering, and medicine. And obtaining patent protection is a key milestone on the path to commercial success. So as researchers, it's important to learn to navigate this crowded, competitive landscape for your ideas to reach the public as a product. So this webinar is going to explore strategic considerations for drafting and prosecuting patent applications directed to these inventions. Got a couple of great speakers lined up for you today, but before I introduce them, I just want to go over some housekeeping items. First of all, we welcome your questions at any time. Feel free to drop them in the Q&A section. Please don't use the chat as that has been disabled. So if you have any questions, just put them in the Q&A. This webinar is also being recorded. So if you know someone that's interested in this topic and they weren't able to join us today, just let them know it will be available as a recording on the Office of Technology Development website later on. So let me go ahead and introduce our speakers. Today, our first speaker is Donald Prather, a principal patent attorney at the law firm of Meunier, Carlin and Curfaman in Atlanta, Georgia. Don's practice focuses on preparing and prosecuting domestic and international patent applications for clients in the pharmaceutical, chemical, and biotechnology industries. For clients in the life science and biotechnology industries, Don's experience includes therapeutic antibodies, recombinant protein therapeutics, RNAi therapeutics, gene therapy, human vaccines, veterinary vaccines, and in vitro diagnostics. Prior to becoming an attorney, Don spent several years with the Center for Disease Control and Prevention as a licensing associate with the Technology Transfer Office, where he drafted and negotiated intellectual property licenses with industry partners ranging from small biotechnology startups to major multinational pharmaceutical corporations. He received a BS in chemistry from Eckerd College, a Ph.D. in genetics from Harvard University, and his J.D. from Georgia State University College of Law. Our second speaker, Gibson Lanier, is also a principal patent attorney at Meunier, Carlin and Curfaman. Gibson focuses his practice on providing counsel to his clients in all aspects of foreign and domestic patent prosecution, interference proceedings, and post-issuance reissue and reexamination in the biotechnology, medical device, chemical, and pharmaceutical industries. For clients in the biotechnology industry, he advises and prosecutes patents for vaccines, immunological therapies, DNA and protein therapeutics, antibodies, stem cells, immunological screens, biomarkers, transgenic animals, gene therapy, molecular and cellular biological screening assays, diagnostic sensors, and peptide protein therapy. His biotechnology experience also extends to medical devices, advising clients on surgical devices, implants, medical imaging, sensors, and bioreactors. Gibson received his BS in biology and his Ph.D. in microbiology and immunology from Emory University and his J.D. from Georgia State University College of Law. So we've got two very qualified speakers, and I'm excited to have them talk to you today. So take it away, Don and Gibson.
Thank you all thank you, Dana, for that introduction, and thank you to everyone who's able to join this webinar today. So our firm, Meunier, Carlin and Curfaman, we've been able to work with a number of you at FAU already, and we look forward to working with others of you who haven't had a chance to work in the patent space. We'll look forward to working with you in the future. So while today's talk is going to focus on patenting life science and medical device inventions, for those of you who may be on the webinar who are not necessarily in these areas, there's still plenty to take away in those areas as well. Just again, we'll have some nuances and specifics that relate to life science and medical device innovations. But certainly, we have 50 other attorneys and agents across the spectrum of all FAU technologies. So you can see on the left there, the four different research institutes. So really any research that's coming out of FAU, we have experts who can handle that area. So again, today's talk is focused in life science, medical device innovations. So what do we mean by that? And Dana already alluded to this and discussed this in the intro. It's really, you're looking at the intersection of life sciences with engineering, with technology, and really you're seeing different overlap of the life sciences with these different areas. And as you can see by the sort of the bubbles on the outside, you can see this leads to basically lots of different types of technologies that we consider life sciences, right? From on the left, the treatments, the small molecules, the antibodies, the therapies, gene therapies, cell therapies, to devices, to implants, to stents, and again, nanoparticles, materials, all that then bleeds over to the software and computer. So again, we see from a patent perspective and an innovation perspective, all these different technology areas overlapping and coming together. And you're going to see this in your FAU research as well, right? You're collaborating more with different faculty members. You're reaching out to people in different areas that you haven't necessarily reached out to in the past. And so again, we're seeing that in the innovation and patent space, and likewise reflected in your research as well. So we've talked about the types of technologies that we'll focus on today. Again, life sciences, medical device innovations. But what are the types of intellectual property that, if you have a technology in the life sciences area, what are the different types of intellectual property that you need to think about when you're interested in protecting your invention? And again, this talk is going to focus on patents, but we just want to briefly touch on, you also need to be aware of trademarks, copyrights, and trade secrets, right? So trademarks are those word marks or symbols or logos that distinguish your goods or services. So if you see a Nike swoosh, it's a Nike product. Copyright protects literary works, artistic works, musical works, and trade secrets. Again, that's sort of like the Coke formula, right? Things that are the secret sauce of a product, but aren't known to other people and aren't easily engineered, right? So that's sort of the four different types of intellectual property. Today we'll focus on patents, right? Patents are essentially kind of the flip side of that trade secret, right? You may want to keep your invention a secret, right? If that's the case, then you're not able to get a patent on it. But if you are willing to disclose that write-up and that in a patent, then you can get a patent, right? So again, you can see at the bottom there, we've got the FAU tech development website, right? If you're looking for more information, that's a good place to go start as well. There's different information on the different types of intellectual property, and again, more details about patents and the whole invention disclosure process that are all on the FAU website. So I guess first, what is a patent, right? If we're going to be talking about patents. So a patent is the granting of a property right that provides the inventor with exclusive rights to exclude others from making, using, selling, offering to sell, or importing the patented invention for a designated period of time in exchange for a comprehensive disclosure of the invention. And so just to repeat and reiterate the crux of that, it gives you the exclusive right to exclude others, right? And so we just bring this up just because there is some confusion as to what exactly, when people get a patent, many people think that this then gives them a right to go ahead and produce their product or their widget, when really what it's giving you is sort of a monopoly and an exclusive right to exclude others from the practice copying your invention and practicing your invention, right? If you're starting a company, if you're interested in IP, if you're licensing something out of the university to a company, right, you need to be aware of your own patent, but then you also need to be aware of the adjacent patent space and, be aware that other people can exclude and block you as well. So as you're developing your technology, as you're interested in developing patents for your life sciences technology, be aware of what exactly you're able to do with your patent and what other people are able to do with their previously issued patents, right? So that's, and again, in terms of the patent process, right, it's the United States Patent and Trademark Office, which is part of the Department of Commerce, which handles the back and forth of patent applications and then grants those issued patents. And again, it's from a patent is essentially from a policy perspective, right? The patent office wants to incentivize you to disclose your inventions, right? Just like you publish your inventions and in articles and different manuscripts, right? The patent office incentivize you to disclose, and in exchange for that disclosure of your invention and technology, which further benefits all invention and innovation, right? Then you get this limited patent monopoly, and we'll talk about exactly how long you get in a few slides. So that's a little bit about what is a patent, and again, we'll go into the details of the patent process, but why patent your inventions, right? So first, you may need a patent to develop your technology in certain fields, and again, this talk is focused on life sciences and medical devices. So certainly in those areas, if you want to develop a small molecule therapeutic or an antibody therapeutic, you're going to have a patent in order to license that, in order to develop that technology. All right. So in some cases, you'll need it to develop your technology. In other cases, maybe you want it to showcase and market your technology, right? You can take that technology, you can license it to a big company or a small company. If you're an entrepreneur and you think you can do it, maybe you're interested in a startup and developing your technology and marketing your technology through a startup. In addition to getting your technology out there and sort of commercializing it, right? If you do file patents, and if you do then end up licensing them, it does bring back licensing revenue to you as the inventor, and also licensing revenue to the university. And you can look exactly what FAU's split is between the inventor and the university, and the inventor's lab and the department and the institute, sort of how that's all broken down. And you can find all that on the website as well, or you can always reach out to Dana. So yes, you're not only able to commercialize your technology, but you're able to bring in revenue. And finally, at the bottom there, universities exist in the context of innovation and economic development, right? The universities are part of overall economic ecosystems. Again, sort of the most famous ones, Silicon Valley is tied to Stanford, and Kendall Square in Boston is tied to MIT and Harvard, right? So you've got universities, the technologies that are coming out of those universities. You've got, again, at the university, you're training students. Those students are coming out of your labs and able to work for companies and sort of run with different technologies and develop them. And so that all forms part of the innovation and economic development system there. And again, FAU is part of that whole South Florida, all the way down from Miami, all the way up the coast, that whole ecosystem. And again, it just allows you to be part of that innovation and economic ecosystem. Just to further reiterate sort of universities and its tie-in to economic growth and sort of funding and disclosures. This is just a graph that is able to show you, sort of visually over the past few decades, the growth in university disclosures, startups from universities, executed licenses, and overall licensing incomes. And you can see that, over the past few decades, the growth has been really great. It's the universities, again, this has sort of developed over these past few decades, have really been engines of growth. And so this sort of parallels what we see from sort of funding from NIH, and likewise at FAU, you've seen great increases in funding for research, and likewise that will then lead to increases in invention disclosures based on that funded research, increases in patents, increases in licenses. Right? It's sort of a long process, and it all takes time. But as you get more involved in that process, and as it sort of builds on itself, it does sort of grow over time. So that's sort of what patents are, why patent them at all in the university ecosystem. And so let's just dive into more about the patent process. What are the types of patents in the life sciences, and what is the typical process for a life sciences patent? Right. So the different types of patents, there's three main types of patents: utility patents, design patents, and plant patents. Utility patents are those that are issued in connection with new and useful processes, machines, manufacturers, compositions of matter, or improvements. We've already talked about the examples on the initial slide where you saw all the different types of technologies in life sciences, in medical devices. Those are really, when we're talking about that, those are all utility patents, right? In addition to utility patents, just so you're aware, there's also design patents and plant patents. So design patents are, for example, like the iPhone has design patents to protect the ornamental design of the iPhone itself, right? So you know that people cannot just copy the iPhone design and and sort of tread on the goodwill that Apple's built up through the design of their iPhone, right? So that's one example of where you would use design patents. And for those of you in the audience who may be involved in plants, you can also do plant patents. Again, we won't go into those today. Everything we'll be talking about today involves talking about utility patents. And so we'll talk about, again, what are those different types of patents in that process, and what do you need to do to get a patent in life sciences? So again, we talked about the 3 types of patents. This just tells you the patent term. We talked about what the policy is behind patents, and that it's sort of a quid pro quo for you disclosing your invention and letting the world know exactly what you're doing, that the US government will give you this limited monopoly. For utility patents, right? That's 20 years. For plant patents, it's 20 years as well. Again, that's from the earliest non-provisional filing date, and we'll get into some of those details in a bit. Design patents last 15 years. So again, in terms of the patents that you'll see on the next slide, we'll talk about sort of probably what would be your first patent application that you would see. So for example, so you're in the life sciences, you're working in a medical device lab, and you've got an idea for a technology or an invention. And so you reach out to technology development and Dana, you say, I have this great idea. She asks you to fill out an invention disclosure. And from there, right, she will look at the technology. She'll decide if, okay, yes, we want to go forward with a patent application. And then what you're going to see at the start here is a provisional patent application. Okay, so what does that provisional patent application provide? It provides you with a filing date, right? So we are now in a first to file system. So if you've been around the patent system for a while, you know that before it used to be a first to invent system. So whoever was the first inventor would be the one to get the patent. Not so now. Now, if you have a competitor who's out there and say they invented something after you, but they got to the patent office first and filed it first, they would be the ones to be awarded that patent. So again, you can kind of see this in the CRISPR fights between UC Berkeley and the Broad Institute, fighting over, exactly who was the first to file, first to reach the patent office, and, what exactly did they get on file at the patent office. So again, that first application is a provisional patent application. It gets drafted, right? You draft the different parts of the application, sort of supports your technology, but it doesn't actually give you patent rights, right? The provisional patent application is not actually examined. It's sort of that initial placeholder. And on the next slide, we'll get to sort of what the next steps are in order to get your application. So for that provisional patent application, right, it has simpler, it's more simple than the later patent applications. So, right, you don't have to file claims. The fees for filing are really low, right? The idea is, they want more people to file these patents if possible, right? And so while it's simpler to file and maybe these things are not required, generally as a rule, we still want to file the best provisional patent application that we can. We do want to file claims, right? Claims are the part of the patent application that actually cover the metes and bounds of your invention, right? There's a whole sort of description part of the application, and then there's the claims, which tell you exactly, sort of like a property deed, it tells you exactly what you've got covered, what your patent space is. So once you've got that, right, you get your provisional patent application on file, you can then say that you've got patent pending status, right? You can use that for marketing. At that point, then you want to go out and talk to different companies. You want to talk to industry representatives. You want to try and get your technology out there. All right. And you can say, look, we've got the application on file. And then you can talk to them more about that application. I do want to mention at the end here what we call cover sheet provisional applications, because some of you on the call may have heard this term before or may have used sort of this type of provisional application. And essentially what this is and where it comes into play is it's sort of an emergency provisional patent application. Let's say, you as a faculty member or grad student or postdoc, you've got a presentation tomorrow, or you've got a manuscript that's going to go online, and you remember from either from this talk or talking to Office of Technology Development or Dana in the past that, hey, I should, this looks like a commercially viable idea. And I know if I publish this, then there will be some patent rights lost. And so you'll reach out to Dana. And again, there's not much time to file a full provisional patent application with full claims and great support. But there is sort of an emergency sort of stopgap where we just sort of slap a cover sheet onto your presentation or your manuscript, and at least we'll give you some protection against that public disclosure. We don't necessarily recommend it, right? It's sort of like an emergency stopgap, but just want you to know, because it does come up a lot in the university setting, just because you have to publish, right? You have to get things out there. You have to make presentations. And maybe you're new to the patent system and you just don't know yet. Or maybe you've been involved in the patent system, but again, you just forget because you're busy publishing and trying to get your work out there. And then you remember, hey, I need to reach out to technology development and get something on file before I publicly disclose this. So again, that's sort of the basics of filing your provisional patent application in the life sciences. And again, talks about that cover sheet provisional patent application process, which can also come into play. So the typical university patent filing strategy, right? There's a lot of information on this slide. We're trying to cover a lot of ground in this slide, just to give you an idea of what the sense is for, if you come up with an idea at FAU, or if you're a grad student or postdoc and you move on and you're a faculty member somewhere and you come up with an idea, right? What is the typical patent filing strategy in the life sciences and medical device fields? So first, you're going to file that provisional patent application. We talked about that on the last slide. Again, that's going to be generally your first introduction to the patent process, right? At that point, we mentioned it's not examined, right? So essentially it puts a stake in the ground. You've got your filing date so that, if anyone files later than you're protected, right? At that point, once you file that provisional, you start a clock, and 12 months later, you have to file what's called the conversion patent application, right? You either file a U.S. non-provisional patent application or an international PCT application. If you only want to file in the U.S., maybe you just go into the U.S. directly, or maybe, again, you had a public disclosure that affected your foreign patent rights, and maybe it only makes sense to file in the U.S., and so you only go with the U.S. Alternatively, if you want to give yourself the broadest potential protection and sort of buy yourself more time to reach out to industry and try and get your technology licensed, then you can file the international PCT application. Again, that will buy you another 18 months of time before you have to decide what ultimate countries you want to go into. So you can see, the next stage there, that's the national stage patent applications. At that 30-month mark from your original filing, you then have to decide which countries you want to go into, whether, again, and if you've got a license to a company, then you'll ask the company, well, where do they want to, what countries do they want to enter? Or where are they going to manufacture? What are they interested in? If it's not licensed, right, then maybe you just go into the US and try and get your US patent, and try and go with that. Once you do enter the national phase, then you enter the round of what's called patent prosecution. And this is sort of another 1 to 2 year process where you're going back and forth with the patent examiner. The patent examiner will issue these office actions where they'll look at your invention and they'll do a search to find what they think is the closest prior art. If they find something that they think is sort of right on what the invention is that you produced, then you may get what's called a novelty rejection. If they don't find anything directly, and what they'll do is they'll sort of combine different references to give you what's called an obviousness rejection. And again, we'll talk about some of these requirements on the next slide, just to give you an idea of, okay, this slide covers sort of the patent process for life sciences. Next, we'll tell you about all the different patentability requirements. And sort of after that, then Dr. Gibson Lanier we'll go into some of the more specifics about life science patents, things you need to know specifically about issues you'll deal with in the life sciences, and things that will come up during the patent prosecution process. So finally, once you get through that patent prosecution process, you'll get to that issue patent, and that issue patent then is your enforceable patent, right? That is when you can then go out and your exclusive right to stop other people from copying what you're doing. Again, whether it's a small molecule, whether it's a therapeutic, whether it's a diagnostic, you can then exclude others from doing exactly trying to copy you and practice your technology. So with that, so we talked about the patent process itself. Now, what are the ultimate requirements for patentability, and sort of how does it tie into life sciences, inventions, and medical devices? So this slide just lists the different requirements for patentability. First, it has to be patentable subject matter. So it has to be a process, machine, manufacture, composition of matter, or any new and useful improvement thereof. And again, next slide, we'll go into a little bit more detail of this, and Gibson will talk about some of the issues that have come up lately over the past, say, 10 to 15 years that have made this issue a little bit harder in life sciences, but something that we can deal with. So first it has to be patentable subject matter. Second, it has to be useful or have usefulness. So for instance, you can synthesize a new chemical molecule just because you can synthesize it, but if you don't know what it does and you don't know what its use is, then you can't patent that, right? It has to have some sort of utility. It has to inhibit an enzyme. It has to be useful for a treatment of some disease, right? It just has to have some utility. After that, you have to have novelty, and it has to be non-obvious. We talked about that a little bit on the last slide in terms of the process and where that will come up during patent prosecution and the office actions. Again, what the examiner is going to do, he's going to search for those closest prior art references, whether they're previous patents, whether they're articles, presentations, anything that's disclosed to the public. If you find something that's too close, right, and thinks it reads right on your technology, you'll get what's called a novelty rejection. Again, if it's not exactly the same, but it's sort of similar, what the examiner is going to do, and you'll see, and again, this is probably the most common rejection that you'll see in the life sciences. The examiner will take different patent references or articles and combine them together and say, look, even though one reference doesn't have everything you're claiming in your claim and in your invention, right? All these together, it would have been obvious for someone skilled in the art to put these different references together, and thus it would have been obvious. So again, I'm not going to go into the details of how to overcome these types of rejections, but just so you know, that as that's sort of one of the most common types of rejections you'll see. And then finally, you've got the disclosure requirement. We talked about the quid pro quo of disclosing your invention in exchange for the exclusive right to the patent and the ability to exclude others. And so terms you may hear about written description or enablement or indefiniteness, or there's different other types of disclosure requirements, but those are the types of things that you may also hear about, and sort of will be sort of on that checklist of additional things that we need to think about as patent counsel in helping you frame your invention in the context of getting claims that are the proper scope to get your claims allowed. And just to touch quickly on this issue of non-patentable subject matter in life sciences, so there are these 3 judicially created exceptions, right? So it's not in the statute, it's not something from Congress, but it's something from the courts and the case law that's developed in patent law over the past, over the past few years. These judicially created exceptions, so things that are that are not patentable, right? Laws of nature, natural products, and abstract ideas. The top 2, the laws of nature and the natural products, are really the things that you'll encounter in the life sciences area. Laws of nature will come up in sort of diagnostics, and natural products, right? If you have a gene sequence or a peptide sequence that's the same as the naturally occurring peptide, say it's a portion, things like that, but it hasn't been changed, you haven't included mutations or or engineered it in some way to make a chimera, then you're going to face this issue that, it's the same as a naturally occurring product, and you can't get a patent on that. Finally, that abstract ideas, that's more for the sort of software space, but does come up occasionally in the life sciences as well. But so that's essentially where I'll leave off today. From here, we're going to switch over and you'll hear from Gibson Lanier, who will he's going to talk more about sort of all the different types of life science technologies and sort of dive into some of the more nuanced areas of trying to get a patent in life sciences and some of the areas of sort of patent issues that you'll face as an inventor. So Gibson.
Thank you, Don. Everybody hear me okay? All right. So as we mentioned at the outset, when we were going through the bios of Don, myself, and the kinds of things that are typically we work on, that covers the breadth largely of life science and medical device patents. But I've got here some broad categories listed of things that you would typically find in life science and medical device patents. Certainly pharmaceuticals, the small molecules that are created, modified cells, proteins, peptides, and genes. So key there being modified. So if you are able to make a transgenic cell, or you've modified a protein for better expression, or to elicit a particular effect enhanced, or maybe it needed to be modified in order to be utilized in a medical application. Similarly, peptides and modified genes, all those could be patented and would fall under the life science patents. Techniques, CRISPR, PCR, those kind of things that you might use in the laboratory, but also could use in the clinical areas. Those techniques can be patented. Medical devices, implants, instruments used in surgery, diagnostic sensors, those types of devices certainly fall within the life sciences and medical device patents. Medical imaging, so MRI techniques, that new ways to process the imaging, new instruments, dyes, anything that would enhance the ability to utilize or even come up with a brand new way to image the human body or image parts of the body, certainly would be patentable. Now, diagnostics, this is a tricky area, and we'll go into why in just a moment, but diagnostics would be, you could, new diagnostic technique, instruments, methods of making a diagnosis. As we'll discuss in a second, there are aspects of this that are patentable, aspects that are right now under the court systems are not, but certainly they would be in the life sciences device patents. Vaccines, modified pathogen subunit vaccines, cancer therapeutics. It just doesn't have to be against a pathogen. It can be against cancers as well. This would include both prophylactic and therapeutic vaccines, immunotherapies, so checkpoint inhibitors, CAR T cells, tumor infiltrating lymphocytes, methods of generating those be immunotherapies, antibodies. So I think we're all familiar with what antibodies would be, but this would also include nanobodies, diobodies, bispecific antibodies, things that would have an antibody structure, so single chain variable regions, maybe a structure that has both an immunotoxin, for example, which would have a toxin moiety bound to an antibody, and then, of course, methods of treatment. Next slide, Don. So, as we said before, or as I said just a second ago, diagnostics have particular issues facing them. And as Don mentioned, within life science patents, there are some issues that come up with respect to subject matter eligibility. So subject matter eligibility, as Don mentioned, are exceptions to the composition, articles of manufacture, process, and the aspects of the areas in which we consider the patent has to fall under those 4 categories. Well, these are exceptions to that. And so if you have a naturally occurring product, certainly, or a law of nature, so law of nature would be you can't patent the law of gravity. You also can't patent things that are directly out of nature. So naturally occurring products will be non-modified plants, proteins, cells, genes, non-modified animals. More recently, cell-free fetal DNA that was being used in diagnostics, but the way the claims were drafted in the patent, the courts determined that that was looked like somebody trying to patent the existence of cell-free fetal DNA, and that in and of itself is a natural product. Diagnostic, so you because those are already there, somebody trying to get a limited monopoly on the use of that thing, the courts rightly have determined one should not be able to do that, because those are things that exist in nature. Now, diagnostic techniques and technologies are problematic. So until about 10, 15 years ago, diagnostics were a heavily valued part of most company and university patent portfolios with respect to life science innovations. Certainly, the ability to recognize when somebody has a particular ailment is very, very useful, particularly in cancer therapeutics, where the timing of when somebody is diagnosed initially with the cancer can be critical to whether or not they can be treated successfully, and also determining what treatments that person might be appropriate to receive. So some sort of biomarker that would indicate that a particular therapeutic would be appropriate for that individual. 13 to 15 years ago, there were 2 cases. One was Association of Molecular Pathology versus Myriad, and the other was Mayo v. Prometheus. Both of these cases turned on diagnostic applications. And Myriad, you may recall, revolved around breast cancer diagnosis using the BRCA1, BRCA2 genes. What they did there, the courts found that the cDNA used and discovered was not a naturally occurring product, so that was okay. But the use of the information that was described in the patent application touched on 2 areas. One was an abstract idea. It was the correlation of the information to a particular outcome. So if you had this particular biomarker, you have the disease. The second was the biomarker itself. The biomarker is a natural product. It's actually a natural phenomenon. This gets elevated. And this came out of those 2 cases I mentioned. One was in Mayo v. Prometheus, there was a metabolite that was claimed and used to determine how much of a drug to administer. And so the drug gets processed in the body and becomes a metabolite. And people would recognize that just dosing something based on the size of somebody may not be appropriate. Really, what matters is the amount of metabolite they had. Well, because the metabolite naturally is a natural outcropping of being administered this drug, that was considered a natural product. The other thing recently that's been impinging on life science innovations is enablement. So in order to obtain a patent, as Don described, you need to make a disclosure of your invention. And you have to disclose it in such a way that teaches others how to make and use your invention. Well, right now, there is a case between Amgen and Sanofi that's before the Supreme Court, and it's looking at exactly this with respect to antibodies. Amgen had described, I think it was around 30 examples of antibodies that existed that had the particular properties of their claim. And Sanofi noted that, well, there's thousands of antibodies that could fit this description. And then Amgen hasn't described the full breadth or scope of all the possibilities that are there. And so right now, the Supreme Court is determining whether or not Amgen met that hurdle. Now, they don't have to teach everything associated with their invention. They have to teach somebody how to make and use it, and that anybody is somebody of skill in the art. Generally, just and that person of skill in the art is a hypothetical person, and it does vary depending on the technological burden of the particular technology. But in the biosciences and chemical sciences, that is generally a postdoc level person or higher. So there's an amount of assumed understanding. And when you're looking at whether somebody's enabled it, there can be some, they don't have to teach you every aspect, as long as it doesn't require some sort of undue experimentation for you to connect all the dots. If they tell you to perform a PCR assay and they don't have to tell you and explain how to do PCR, they're assuming that everybody that reads their particular patent will know PCR. And so they shouldn't have to do that. Well, right now, that's what that court case is about. And Amgen and Sanofi, they're sort of battling out what's there. So now we've got an example of a life science patent. I pulled something from the USPTO that was based out of here. This is Dr. Fields, and it's a compound of formula A. So formula A is the chemical structure right there with all in the upper right-hand quadrant of claim 1. And you can see here that they've defined in claim 1 all the variables within it. So they've got compound A has a particular formula, group Z is defined as having one of a couple of possibilities. All the X1 through X6 and Y1 through or X1 through X7 rather, and Y1, 2, and R5 and R6 are all described as having certain particular features. And this is what you would see in a small molecule patent, is somebody describing all those features. And in further claims, so this is just the first claim, is the broadest claim in the patent. You might define further with specificity what each of the X1, 2, 3, 4, 5, 6, 7, each of those groups are, or might more specifically define what group Z is. You might add additional features to it. And next slide, Don. This is another one. So you've got a cyclic peptide in this particular case fitting a certain formula. And again, we are describing what X, X1, X2, X3 is. You'll note that X, for example, is amino acid sequence having the length of M amino acids. Well, it doesn't say what M is. And so in a further claim, we might describe that further. X2 is amino acid sequence having 5 amino acids. X3 similarly. So there is some amount of variability within the claim, but it has ultimately, whatever comes about will have that same lysine, XM lysine cyclo with a cysteine, a phenylalanine, and then an X1, X2, X3, then another cysteine, followed by a threonine. And they'll always have that basic formula. And you see in the drawing that it describes what that would be used to effectuate, and it's intranasal administration to alleviate pain addiction. I guess, and it avoids one having to give it intravenously or through a capsule, which have problems with respect to degradation. Next. Okay, so now when you start the patent process, one thing is often helpful, and one of the things that mainly inventors come to ask, and the technology transfer office will ask you, is how crowded is the field of endeavor that you're in? Are there other patents out there that would inhibit you from either patenting your invention, or even if you were to obtain a patent, would prevent you from actually practicing the invention? So as Don mentioned, as Dr. Prather mentioned, this is an exclusionary right. So it's a right to exclude others from practicing your invention, but it doesn't give you the right to to practice your invention, because there might be other things that inhibit you from doing that, such as somebody having another patent. If you have a patent, for example, of the use of a particular peptide as a therapeutic, and it's a non-naturally existing peptide, but somebody else has a patent to the peptide itself, well, you would have to obtain a license from that other party in order to obtain your patent, because or enable to utilize your patent for the method that you created, because they have a patent with rights to that particular peptide. Similarly, during patent prosecution, as Dr. Prather mentioned, you're going to have to, an examiner is going to look at this and determine whether you're the first to invent whatever it is you created, or whether it's obvious to do what you did, and they'll conduct a prior art search. Well, it is often useful to know what these things are before a patent application is being drafted, because you can oftentimes draft around these problematic areas, or if you can't, know it's time to just cut bait and move on. To do that, you can conduct a patent search. You can do this yourself. Now, you can certainly go to the Office of Technology Development, and they will certainly probably do a search on their own, but they're going to ask you on their form if you are aware of anything else. And if you've already done some searching, that will greatly help the efforts. And so there are places you can go. You can go to the the United States Patent and Trademark Office website. You can search on Google Patents, free patents online. You can go to the World Intellectual Property Organization. All these websites have Boolean operated search fields that allow you to search the patents or patent applications that are on their in their system, and find out if somebody's started pursuing this in the patent world. Now, you can also do a prior art search on PubMed, or any other database of scientific journals, and that is also useful, because the examiner is not going to be focused just on patents. They're going to be focused on any disclosure, meaning a presentation where the slides are online, or maybe just an abstract from a meeting that is particularly enabling. They're going to look at scientific journals, both peer-reviewed and non-peer-reviewed journals. They're going to look on websites to see if maybe you put something out there on your own. But that's what they're going to look for. And as an inventor, you have a duty to disclose to the patent office anything that might affect the material patentability of any one claim in the patent. So, when is something ready to patent? You've come up with an idea. That's fantastic. You might have even gotten to the point where you've obtained some data, but you know that you've created, if you're in the chemical field, you're a small molecules. Okay, you've got small molecules, and it might be years before they are market ready. Well, this timeline sort of gives you an example of when things happen. Patenting, once you have a conception, once you start to have some data to support your idea, then that's when you are market ready. That's when your patent, you're ready to move to a patent. Next slide. Okay, so what is inventorship? I'm going to quickly go over this because I've received notice that we're sort of getting close to out of time. So inventorship is somebody who contributes to the conception of the invention. That's the fully fleshed out idea, the novel aspects of it. A person can be an inventor. It's a legal determination. It is not the same as authorship. So just because Dr. Smith in the lab next door gave you some reagents or gave you an animal model that you could work with, and you put them on the paper for that contribution, that does not mean they're an inventor. They have to be contributing to the conception of the invention itself. It does not have to be all aspects of the invention. Patent applications involve claims, so being an inventor on a single claim is sufficient. Don, next slide. So who owns the patent? The ownership patent starts out as the inventor, but then it is typically, at least in the United States, starts out as an inventor, but typically ownership falls to to the university in the case of things created for Florida Atlantic University as part of your employment agreement. We will oftentimes ask you to make a confirmatory assignment of rights, but it is understood that the university is already the owner of that. Next. Okay, so types of intellectual property. Don mentioned before, we've got trademarks, copyrights, trade secrets, and patents. Real quickly, we'll go through those. Trademarks just are any word, name, similar device that identifies and distinguishes the goods or services of a business. You'll typically see the R with a circle around it, or a TM, or an SM at the end of a word. These can be colors, they can be sounds, they can be a stylized representation of the world. Think of the way the Coca-Cola script is. Home Depot has its orange color. UPS has brown. The Nike swoosh. The sound of a Harley Davidson, because that's related to the engine misfiring. All those identify with particular products. The sound of the drummer beat, the little rabbit beating the drum on the Energizer Bunny commercials. Those are all trademarked. They are good in perpetuity, but have to be renewed every 5 years. Copyright is protecting the original literary, musical, and artistic works. They have to be independently created, and they have to be fixed in a tangible medium. They're good for 70 years after of the life of the person. But there's no real requirement that you go to get the copyright registered, but that's there as well. So trade secrets is information that's not readily known or ascertainable. The problem with this is it's the opposite of the patent world. In the patent, you're giving up the secret to get rights to prevent others from performing your invention. But after that end of that 20-year period, the world can practice it. Trade secret's good as long as you can keep the secret. And you have to go through certain steps to maintain that secret, but it doesn't prevent somebody from reverse engineering it. So if somebody's able to reverse engineer it, they've avoided your trade secret. Next. Okay, so this is patents, invention with commercial potential. So the Office of Technology Development will make an assessment and look for market opportunity. So please disclose your invention early and think broadly of how your invention can be applied. There will be companies expressing interest in your invention. So the OTD will make it known what inventions are available for licensing and the technologies that are being put out by the university, and companies will approach them and they'll approach companies. And we, one of the best contacts for many companies are you, the inventor. So it's important to talk about that with OTD early, about your ideas and where you sit, and they can help you walk through this process. Next. Questions?
Great. Thank you so much, Don and Gibson, for that excellent presentation. I know whenever we give webinars on intellectual property, there's so much to talk about that an hour is never enough time. But we do have a question here that was submitted by one of our attendees. And they asked, am I able to apply for a patent on a medical device invention after I have already published about it extensively?
Yeah, I'll take that. This is Gibson. The answer is it depends. So internationally, no. Internationally, you would be excluded in most countries because most countries have an absolute disclosure rule where if something has been made available or utilized in the public eye, then the next day you're excluded for patenting that. In the United States, if your publications and public use has occurred less than 1 year, then yes, you could obtain a patent. There are some other countries that have similar time, I guess we'll call them grace periods, but other than that, no, you wouldn't be able to patent it. If there's some new modification to your device, then maybe the new modification, as long as that's not obvious, or there's a new utilization of it possibly, but again, if it's outside the year, then you'll be foreclosed.
Great. Thanks, Gibson. If anybody else has any questions, feel free to drop them in the Q&A now. I have a couple of questions. Dawn, you discussed the timeline of the patent application process. I was wondering if you could speak a little bit about how federal funding might impact the timeline to file a patent application, because a lot of our researchers receive federal funding to work on these inventions.
Yeah, so federal funding can come into play when it comes to the timing of your sort of when you have to convert that application. And really, so we talked about the provisional stage, right? Once you file that, we said you have 12 months until the next stage. And while that's generally the case, and probably most patents have that deadline, when there is federal funding involved, there was a sort of a recent change where you need to file that by the 10-month period. So instead of, you may hear a 10-month conversion deadline instead of the 12-month conversion deadline. There are ways to extend that and sort of get back to the 12-month if you want. But generally, if there's federal funding, then the conversion would be sort of at that 10-month stage. But for most purposes, the federal funding it's not going to affect your sort of original provisional filing date, and it's not going to affect sort of national phase countries. Really, where that comes into play again is at the conversion, and whether ultimately that's a 10-month or a 12-month. So you just want to make sure you're aware of, when you get to that conversion, that you're aware that you may need to file by that 10-month period.
Thanks, Don. I can see we're just about out of time. So if anybody else has any other questions, feel free to reach out to Don or Gibson. Their contact information is up there, or you can reach out to me. Again, my name is Dana Voglitis. I'm the Associate Director of the Office of Technology Development here at FAU. So we're responsible for the legal protection and commercialization of any intellectual property, whether it's patents, copyrights, trademarks, that comes out of FAU Research. And we're happy to help you at any time. So you can email me directly, or you can use our general office email, which is techdevelop@fau.edu. And I'd like to thank everybody for attending today's webinar, and we look forward to seeing you on a future one. So thanks again, Gibson and Don.
All right. Thank you.
Happy to do it. Thank you.
All right. And let us know if you have any questions.